Hello friends, in the series on the income tax cases today we will discuss the case of CHANDRAN SOMASUNDARAM versus Principal Director of Income Tax and others. This case has been reported in 450 ITR at page number 188. The matter has been decided by Madras High Court and the date of the judgment is 20th October 2022. In this case, a search was conducted on the assessee on 11th August 2019. Notice under section 153A was sent to the assessee, and there is a requirement that the search team has to hand over the seized documents to the assessing officer for making the assessment within 60 days. So whether this time limit is mandatory or whether it is directory. So the first question which was decided by the court was that this 60-day time limit for handing over the documents to the assessing officer by the search team is only directory. If these documents are issued after that the period of 60 days, even then the notices which have been issued to the assessee are valid. Generally, it is the practice that when the documents are received, then it is a very well thought that only then the assessing officer can issue the notice under section 153A. So it is very surprising that how the assessing officer will issue the notice until and unless he has the documents which has been seized by the search team. But the court said that in section 153A and in 153C, there is no time limit for issuing the notice. The only time limit in section 153B is for completing the assessment, which is 21 months from the end of the financial year in which the last of the authorization for the search is made, and it is 9 months in case of section 153C from the financial year in which the documents are handed over to the concerned assessing officer. So the court said that even if the notice under section 153A and 153C are issued by the assessing officer before receiving these documents, even then the assessment is completely valid. In this case, the assessee was also challenging that the reasons were not recorded and the proper reasons were not there for making the search on the assessee under section 132 subsection 1 clause A, B, C. For this, the court said that by relying on the very recent judgment of the Supreme Court in the case of Principal DIT investigation versus Lalji Bhai, Kanji Bhai, Mandalia 2022, 446 ITR, page number 18. In this case, the Supreme Court said that the formation of the reasons by the officers is not a judicial or quasi-judicial function, but it is an administrative function. What is the impact of this ratio is that the High Court in a writ petition will not involve into the sufficiency of the reasons, whether there are sufficient reasons for making the search or not. If the department is able to prove before the High Court that there were reasons, then the search will be valid. So these provisions, and with due respect to both the courts, are very harsh on the part of the assessee, because it may happen that there are some reasons, because whenever the search will be made, there will be reasons. Whether those reasons are so much acute that you can go to the last resort for making the search on the assessee. For example, if an assessee has expended 2 crore rupees on the marriage of his daughter and the department came to know this, then by recording this simple reason, they can make the search on the assessee. Whether the department has correlated this expenditure with the returns filed by the assessee and by his family members, these, even if those factors are not considered by the department in initiating the search, even then the search will be valid if we draw the right ratio of both the decisions. So this is a very harsh judgment that the recording of the reasons is a administrative function and not a judicial and quasi-judicial function. Friends, at the end of this video, once again I am repeating the name of the case. The name of the case is Chandran SOMASUNDARAM versus Principal Director of Income Tax and others, and this case has been decided on 20th October 2022 and the matter has been reported in 450 ITR at page number 188. Thank you, friends.